5, 4, 3, 2, 1, start.
The final report under Section 173 CRPC dated 20 June 2020 was presented in the court along with a common complaint dated 8 June 2020 by the district magistrate for taking cognizance in 206 FIRs registered during that period. Full stop. He makes a categoric reference to the complaint filed by the magistrate dated 8 June 2020 in specific to para number 5 thereof, wherein it has been averred that as per the report submitted by the Superintendent of Police Rohtak wide number 14742 dated 27 June 2021, the accused persons in the said FIRs have violated the order of promulgation issued by him. Full stop. However, learned counsel submits that no such report forms part of either the charge sheet or the complaint as per the record. Full stop. Chanja. Furthermore, he refers to para 6 wherein it has been mentioned by the district magistrate that the complaint is being filed to meet out the procedural requirement under Section 195 CRPC and Section 60 of the Disaster Management Act 2005 with a prayer to take cognizance under Section 188 of the Indian Penal Code and provisions of the Disaster Management Act against the accused persons. Full stop. In addition, an exemption had been sought by the district magistrate from personal appearance as a witness, being a public servant but not as a complainant, which shows that as a matter of fact the complaint even taken on its value does not meet the requirements of Section 195 CRPC for the reasons more than one, namely it being dated 8 June 2020, that is after the date of charge sheet 22 June 2021, and the same does not disclose any specific allegations 1966 which ought to have been disclosed, which according to the learned counsel is not sufficient, as merely a list of 206 FIRs had been mentioned therein. Full stop. Stanza. The magistrate to take cognizance each complaint ought to have been set up with comprehensive facts based on which the magistrate could have applied his mind to take cognizance thereof or not. Full stop. The report of Superintendent of Police is dated 27 June 2020, which though is not appended with the charge sheet, however, the same is also much after the date of the charge sheet dated 22 June 2020, as is the complaint of the district magistrate dated 8 June 2020. Thus, the documents prepared subsequent to the final report could not form a part of the said charge sheet, which shows that the entire exercise is illegal. Full stop. Even the learned trial court has erred in the present case in as much as while framing the charges against the petitioner wide order dated 3 July 2020 by merely mentioning that from perusal of the challan and other documents appended therewith a prima facie case for offence under Section 188 was made out against the accused, which according to learned counsel is in contravention to the provisions of Section 195, as there was no specific reference to the complaint of district magistrate. Full stop. Stanza. Once the FIR in itself could not have been lodged as has been held by the various courts, the challan prepared consequent to the same could not have been presented, basis on which the magistrate has taken cognizance without applying his judicial mind. Full stop. To buttress his submissions, reliance is placed by him on the judgment of Maharashtra High Court. Full stop. Learned counsel submits that in the case of the Madras High Court has held that FIR cannot be registered for an offence under Section 188, as the same leads to filing of charge sheet which is barred under section 195 CRPC full stop. He further submits that in the judgment of Delhi High Court in Rohan Kasliwal within bracket Supra, it was held that non-compliance of provision of section 195 CRPC is a defect that cannot be cured full stop. Reference to definition of complaint under section 2 of the CRPC was made as per which no complaint would be considered as a complaint under section 195 CRPC unless it satisfies section 2 of CRPC and that mere filing of complaint along with the charge sheet as has been done in the case of the petitioner does not make it a complaint under section 195 CRPC full stop stanza. It is his further submission that the police and no jurisdiction to lodge the FIR and to file a charge sheet under section 173 CRPC in a case involving an offence under section 188 IPC and the magistrate does not have the jurisdiction to take cognizance of the same full stop. Therefore, the order of framing of charges in pursuance thereto is liable to set aside full stop. He refers to a judgment of Bombay High Court which deals with the legislative intent of corporation of section 195 within bracket 1 CRPC full stop. Opposing the petition, the learned State Council has referred to the reply by way of an affidavit of the Deputy Superintendent of Police Rohtak wherein it is submitted that the petitioner had no concern with the mother dairy franchise of his cousin brother in any manner and that there was an intentional violation of the COVID-19 guidelines issued by the district magistrate as per which he had ordered for a complete lockdown in Rohtak for the said period from 6 pm to 5 am full stop. It has been further submitted that FIR dated 28 March 2020 has been registered after which the challan has been filed and charges against the accused have rightly been framed by the learned magistrate wide order dated 3/7/2020 full stop stanza. There are a total of 5 witnesses in this case and none has been examined so far full stop. It is his further submission that the petitioner has concocted the entire story as he along with 4 more accused persons was found standing empty-handed and on inquiry by the police he failed to give any satisfactory reply full stop. Thus FIR has been lodged on absolutely true facts and circumstances full stop. Heard counsel for the parties before delving in the issue it is apposite to refer to the relevant statutory provisions of sections 188 IPC and 195 CRPC which reads thus disobedience to order duly promulgated by public servant whoever knowing that by an order promulgated by a public servant lawfully empowered to promulgate such order full stop stanza. He is directed to abstain from a certain act or to take certain order with certain property in his possession or under his management, disobeys such direction shall, if such disobedience causes or tends to cause obstruction, annoyance or injury or risk of obstruction, annoyance or injury to any person lawfully employed, be punished with simple imprisonment for a term which may extend to 1 month or with fine which may extend to 200 rupees or with both, and if such disobedience causes or tends to cause danger to human life, health or safety or causes or tends to cause a riot or affray shall be punished with imprisonment of either description for a term which may extend to 6 months or with fine which may extend to 1000 rupees or with both full stop stanza. It is not necessary that the offender should intend to produce harm or contemplate his disobedience as likely to produce harm full stop. It is sufficient that he knows of the order which he disobeys and that his disobedience produces or is likely to produce harm. Full stop. Section 195 in the Code of Criminal Procedure 1973. Full stop. Prosecution for contempt of lawful authority of public servants, for offences against public justice and for offences relating to documents given in evidence. Full stop. No court shall take cognizance of any offence punishable under sections 172 to 188 of the Indian Penal Code. Full stop.